morning. This is Hap May with the Legal Play.
And I'm Chelsea El-Azzi, Hap's associate. So Hap, today we are discussing secured transactions.
Right.
And security agreements.
Right. Lending relationships, whether the borrower and a lender, and something to collateralize that just in case the borrower doesn't pay the lender back, the lender can take something.
And I feel like there's going to be a lot of definitions that we're going to need to discuss along the way. You said collateralize.
Yeah, okay. Collateralize is where it's just somebody puts up collateral, something
of value.
And probably the easiest example is sort of pawn shop example.
Right.
You take, your jewelry or a piece of jewelry to the pawnbroker. You sign an agreement that says if you don't redeem it, that the pawnbroker can sell it.
You don't pay him back.
You don't pay him back. Yeah. So they can then sell the piece of jewelry if you don't redeem it, pay them back in 30 days. And typically they give you $100 and you got to redeem it for maybe 120 or something like that in the process. And that in that case, the jewelry, the piece of jewelry, is the collateral for the loan that the pawn shop makes. And there are other examples of that. I mean, businesses will have accounts receivable and inventory and equipment, all of which they don't take to a pawn shop and
right.
get money for. They give the lender a UCC, and UCC is Uniform Commercial Code. Texas has a version of that, which almost all states have adopted in one form or another in the process. So they have this way where they post a notice, a financing statement, usually with the Secretary of State. In some cases, it's with the county, but generally the Secretary of State, letting everybody in the world know that this business's UCC assets, accounts receivable, equipment, inventory, some general intangibles, farm products, depending what kind of business it is, they are pledged, so that nobody else can then file something and think they've got a first lien.
And there has to be a security agreement.
In order to do that, it has to be a security agreement, meaning that the first one has to be an obligation, some sort of debt obligation, where what we'll call the borrower, the obligor, has an obligation to pay. Usually a lender, could be a vendor or something like that, but there's some money that is owed from party A to party B.
And I like the term obligor and obligee better because mostly it's a lending relationship where money is being lent and you're putting up some kind of collateral to say, okay, I'm going to pay you back, and if I don't, you get to keep or have these things.
Right.
But I just did a security agreement recently for a landlord and a tenant who's taking on, who's assuming a lease.
Right. And basically the security there is stuff that's in the building that is being leased that belongs to the tenant.
The FF&E, the
furniture,
fixtures, and equipment. Yeah.
That belong to the tenant, are collateral for the rent obligation to the landlord. And if the tenant doesn't pay, then the landlord can, in addition to evicting the tenant, can also keep the stuff and sell it in a commercially reasonable manner and apply that to the unpaid rents.
And in this case, it was reasonable to expect that too, because the landlord wasn't really wanting to necessarily sell it to recoup losses. They just wanted it all kept in place so that if they needed to get somebody else in there, it was all ready to go.
It does add value to the rental relationship and can induce the landlord to agree on terms that it might not otherwise. It didn't have that collateral.
Yeah.
And that's again. Then there's another series of people who have interest in real estate. Whether it's land or land in the building. In Texas, certain mineral rights, all of which constitute real property. They are done a little differently because the Uniform Commercial Code doesn't apply. Instead, state property law applies. And in Texas, we have what we call deeds of trust. So a borrower will pledge, will enter into a note and loan agreement where they agree to borrow money, they agree to put to pledge their real estate, either on acquisition, that's part of the closing of acquisition, they do so simultaneously, or real estate they already have that they are now pledging to get a new loan or refinance from. They will file there'll be a promissory note saying we're borrowing under these terms. There will be a deed of trust, and a deed of trust is the security, the equivalent of a security agreement in a real estate transaction. And it will then be filed in the county in which the real property is located. And if there is a default on the loan, then there's a process by which it's posted for foreclosure the first Tuesday of a given month, non-judicial, without a court order. The lender can then put it up for auction and sell the real property. And that's the security for the loan is real property. And it has some advantages that everything else does. Everything else we've talked about can move. Or by the time the landlord tries to foreclose or to take possession of the equipment, it's probably very well used. And it may be for a business that didn't work in that location. So it has some different. Land doesn't go in. At least maybe on the coastline there's some issues, but generally speaking, land doesn't go anywhere. So it's not as if somebody could take that, smuggle it out of the country, or somehow make it unavailable for the process. Now we have a non-judicial process in Texas. So if you want to try to stop a foreclosure, it is the borrower's obligation then to come forth and try to enjoin it, file bankruptcy, all of which, typically slows down the process, but doesn't eliminate the fact that there's an obligation owed and the collateral is available to satisfy some or all of that obligation process.
Yeah.
And this is a process when anybody wants to borrow money or to take their assets and use them to collateralize or to allow a vendor or a lender or some other
someone you have obligations to
not immediately try to sue you to collect those obligations. Instead, allow those obligations to continue to exist and feel secure that they will ultimately be satisfied.
Right. Yeah. And the security agreement has, certain elements that have to be satisfied. It has to, describe in enough detail and
there's a lot of litigation over what did it secure, and if the ultimate obligation is satisfied, does the collateral then apply to some new obligation, or is the lien on that equipment or inventory or whatever the asset is extinguished when the original debt is satisfied, or is there's kind of this continuing, and there's various language you can have in that says, okay, I mean, you let you have a line of credit, and even when you pay off that line of credit, when you make new advances, they are still secured by the assets that the original amount was in the process, and it can be done either way. But there are disputes. This is a heavily lawyered area of law, as you can imagine, and in both borrower and lender, obligor and obligee, need to have good legal counsel in the process of doing this in order to protect themselves. One, at the initial negotiations, at closing, as the debt is being performed, and when there becomes a dispute as to what the rights of the creditor are versus the rights of the borrower or obligor in the process, there's a lot to consider.
Right, and making sure that it's on file in the appropriate place.
Right. And
that you're just not holding on to the security agreement and thinking you're good.
Because then somebody could come later on and file. And with UCC security agreements, financing statements, it's the first to file. It doesn't matter who the first to make a loan was. It's whoever filed in the Secretary of State's office first. So if I lent a company some money on Monday, and you lent the company money on Tuesday, and you file your financing statement on Wednesday, and I don't file mine till Thursday, you have priority. So when that collateral is sold or liquidated, you get paid first. If there's anything left over, then I might get some. Otherwise, I'm out of luck. I have an unsecured debt against a debtor that has trouble paying its bills, which is not where you want to be.
Yeah. So that's secured transactions and
yes,
security agreements, and I thought that would be a good topic for today since we did a couple of those. And
we've done that. Yes, we've done that. We do have a habit of what we're doing lately becomes a podcast, and that will probably continue. And we will find some very interesting projects over the next year for which we will comment on a podcast, and we look forward to spending the next year doing that.
Okay. Thanks for being with us, Hap.
All right. This is Hap May with Legal Play.
Bye, everyone.